2025. I am short-term rental property chief Bonnell McBrim III, and I'll be presenting the cases to the board for review in today's public hearing. At this time, I would ask everyone to either turn off their cell phones or put them on silent as not to disrupt today's meeting. The procedure will be for staff to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to the case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period for rebuttal. The board and their rules provide for cases without opposition 5 minutes total for the appellant, including members of the public speaking in support of the appeal, to present their case and supporting comments. For cases that have opposition, the rules provide the appellant, including members of the public speaking in support of the appeal, 10 minutes total for their presentation and rebuttal of the opposition's presentation. The appellant must reserve a portion of the allotted 10 minutes for their rebuttal. For members of the public speaking in opposition, 10 minutes is provided. This is 10 minutes total for all speakers combined and not 10 minutes for each speaker. For members of the public that want to submit comments to be entered into the record prior to the meeting that are either in support of or opposition to an appeal, the comments must be submitted to the board staff no later than 5 days prior to the public hearing. Send comments to strboard@nashville.gov. Documentation supporters or opponents wish to provide to the board after the deadline can be presented to the board members by providing 8 copies at the public hearing. However, the board may elect to defer cases in order to review any materials received after the deadline. The Metro Code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted that if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of a show cause hearing. The board will go through the cases set for public hearing today. After both sides of the case presentations are made, the board will discuss and vote on the case. The board is vested with the power to act on cases before us today under the provisions as outlined in section 6.28.035 of the Metropolitan Code. The code requires 4 members of the 7-member board to be present to constitute a quorum. The board rules require a majority vote in the affirmative of members present to grant appellant's application. In the event that the majority vote is not achieved, the case will remain on the board's agenda for the next regularly scheduled public hearing. Applications that fail to receive a majority affirmative vote at the next regularly scheduled public hearing shall be deemed denied by operation of law. Any aggrieved party may, within 60 days of the entry of an order stating the decision of the board resulting from an appeal hearing, appeal a finding of the board under the common law writ of certiorari in accordance with TCA 27-9-101 and following to the Chancery Court within the same 60-day period. After that time has elapsed, the board's decision becomes final. No further action may be taken. If you are an appellant and your case is granted, it is necessary for you to obtain the permit for which you have applied. It should be noted that the permit must be obtained within 2 years for the board approval to remain valid. I submit that all cases have been filed in proper order. All appellants have been notified as required by the code, and all affected property owners have been notified, and legal notification sign requirements have been met as required by the code. Chair Caputo, before we move on to the cases to be heard, we would like to take this opportunity to recognize any elected officials who are in attendance. Seeing none, we will be ready to proceed to the first case, 2025-002.
Daryl Haley.
Is the appellant present? Mr. Haley? This is the second time that this has appeared on the board's docket, 2 consecutive meetings in a row. Therefore, this will be deemed, this appeal will be deemed dismissed for lack of prosecution.
And we don't need to take any action on that, right? That's via board rules? Okay, great.
Correct. Yeah, that's in Rule 4B.
Okay. Moving on.
Our next case is 2025-008. This is property 4029 Aberdeen Road, Keith Madden. Permit renewal denied. The property operated as a short-term rental property with an expired STRP permit. This is an R8 zone district. This is governed by BL 2017-608, as the permit was issued in February the 6th of 2019. That ordinance dictates that the wait would be up to 1 year based upon the decision of the board. At this time, the ordinance did not distinguish between operating with an expired permit or operating without having obtained a permit. The board has discretion under BL 2023-136. On January the 29th of 2019, Benjamin Todd Puckett quitclaim deeded the property at
Sorry to interrupt. Could I just, I don't want her to have to stand.
Oh,
through
I
this whole-
didn't even notice. Ma'am,
Sorry.
please, of course. Come on up. That's okay. Come on up and have a seat. Continue, Max. Sorry about that.
January the 29th of 2019, Benjamin Todd Puckett quitclaim deeded the property at 4029 Aberdeen Road to Benjamin Todd Puckett and Keith Madden. January 31st of 2019, a STRP owner-occupied permit application was submitted. On February the 6th of 2019, the permit was issued. On January 9th of 2020, the permit was renewed. On April 28th of 2020, the property was cited for failure to display the short-term rental permit number in the website advertisement. This was inspector reported and not a result of a complaint. The ad was corrected and the case was closed. February the 6th of 2025, the permit was renewed in 2021, 22, 23, and 2024. February 6th of 2025, the permit expired. February the 7th, Administrative Assistant Alicia Buffer sent Ms. Madden an email to her email address on record, which read, "Your STRP for 4029 Aberdeen Road expired on February the 6th, 2025. I'm inquiring to see if you planned on renewing your permit this year. If yes, the 30-day grace period will end on March the 7th, 2025 at 11:59 p.m. Please renew." There was no response email. March the 7th, 2025, the grace period ended. On April the 11th, the address for the property appeared on the monthly list for April provided by Gronica's host compliance of properties operating with an expired permit. Inspector John Phelps verified the website advertisement was posted and the property was operating with an expired permit. Inspector Phelps sent a notice of violation to the appellant. On April the 22nd, 2025, the appeal was filed. May the 8th of 2025, Inspector Phelps found the website ad remained posted and that it was continuing to operate based on very recent reviews posted on the ad. Inspector Phelps made a site visit to the property and posted a stop work order on the door documented with photos. June 18th, 2025, as of this writing, the ad remains posted with a 3-night minimum stay, but there are no new documented stays. As previously mentioned, the issue date of the original permit was February the 6th of 2029. The grandfathering provision in the TCA, section 13-7-603, require that both this permit and subsequent permit be governed by BL 2017-608. Under this ordinance, both operating without having obtained a permit and operating with an expired permit are viewed the same. Thus, the penalty for both was the same. The ordinance section 17.16.070.u.4.I.7 is the penalty for operating a short-term rental property without a permit shall be, number 2, upon the finding of the board that a short-term rental property is operated without a permit, there shall be a waiting period of up to 1 year from the date of such finding for the property to become eligible for an STRP permit as determined by the board. There were no complaints on either the Hub Nashville or the STRP hotline. There are 4 letters in support and 1 letter in opposition.
Great. Does anyone have any questions for Mr. McBroom?
I do. So I'm looking at the notice of violation, and it says in underlined, therefore you are to have the violation or cause removed and or corrected before May 10th, 2025, and it was issued on April 11th. So I'm confused as to why a stop work order was placed on May 8th if the appellant was informed via the notice of violation that she had to have it corrected by May 10th.
Our procedure, though not dictated by the ordinance, is that Inspector Phelps will go back through the properties that have been sent notices of violation. If they find it, and if he finds that they are still in violation prior to the completion of the remedial time period, he will go to the property and post a stop work order in order to make sure that they have received notification and can make the correction that's necessary in the time allotted. Otherwise, it would result in a warrant to go to the environmental court.
Okay, so I was also just a little surprised to see on the notice of violation that they have a month to correct it. And maybe I've just missed that in previous notices of violation, but I was always under the assumption that once you're informed, you have to correct it immediately. So I was a little confused by that.
I have to agree. I seem to recall letters in the past saying
Immediately. Yeah.
Like, take your ad down and cease all activity, right?
That wording is in there. It's not dictated by the ordinance, and our standard is 30 days. And the reason for that being that dealing with website advertisement, web pages are actually websites that are the vehicle for advertising short-term rentals are sometimes a little difficult to deal with, and so we want to give adequate time for the person to be able to make the correction, because if they're not a property manager and they're not familiar with operating or interacting with the website, it can be an extremely difficult situation depending upon the website platform.
Okay, thank you. I just want to make sure that we keep that in mind as we consider the case and future cases.
Our standard is 30 days.
Okay, great. Thank you.
And has been for years.
Okay.
Okay.
Great. Is there anyone here in opposition to this case today? No? Okay. So seeing none, Ms. Madden. I was about to call you Ms. Keith, so Ms. Madden. I see Ms. Keith throughout the materials here. If you would be so kind as to open the microphone. There you go.
Okay.
And give us your name and your address for the record, and tell us about your situation. You
Okay.
have 5 minutes, but please don't feel like you have to
Oh,
use
I
it all.
won't. I
Okay.
think this can be pretty brief.
Okay.
I'm Keith Madden, and I live at 4029 Aberdeen Road. And I turned over all my finances to I thought I turned over all my finances to my CPA the first of this year, but apparently I forgot about this renewal. And it was honestly just a mistake. I don't even remember seeing the first email. When I got a notification from the nicest man, John Feltz, I immediately called him, and that was dated April 11th. And that's when I was able to get in touch with Alicia and David. Oh, I can't think of his last.
Right.
Yeah. So that's when I immediately started down this path of trying to right my wrong. And I had 2 short-term rentals already on the books that I honestly, they were happening like immediately. And I just didn't feel comfortable telling them, I'm sorry, I'm a lawbreaker and you can't stay in my perfectly good home because I broke the law. I didn't pay to renew my, I understand you've got laws and you've got rules, but it was honestly just a simple, honest mistake. And I righted it as quickly as I could. I've done everything. With regards to the one letter, from George Wheeler. I wish I knew him because I am a really good neighbor. I love Cherokee Park, and I am so grateful to be living there. The apartment that I rent is directly above my home, so I don't have parties. It's one bedroom, and I have people, doctors, that I'm less than 2 miles from Vanderbilt, and I'm half a mile from St. Thomas. I have lots of traveling nurses. I have lots of doctors. I have lots of Vanderbilt parents visiting their children. I have everybody that stays there are really respectable couples, single people or couples. And I've made it really clear that they don't disturb my neighbors. And if you look at all the letters, and I think you were given 2 more today that should have been in the packet, the 2 you got today are, every one you got from me are my immediate neighbors. They love my Airbnb because they use it for their family when they come in town. Nobody complains about my Airbnb because I wouldn't put up with it. They're in my home. They have a separate entrance, but it's above my home. And I have rules about being quiet and parking their car. I'm a good citizen. I just made an honest mistake. And really, that's the long and the short of it.
Okay.
Mr. Wheeler, oh, I forgot to say about Mr. Wheeler. I feel sorry for this man. He lives down the street from me on my same street, and he lives across the street from a horrid Airbnb. It shouldn't be there. I'm embarrassed that it's there. I'm embarrassed that it's in my neighborhood because the things that you don't want to happen in short-term rentals happens there. And this man has a lovely home, and he lives directly across the street from this Airbnb that lets bachelorette parties stay there. And that is not what I do, so
Understood.
I will introduce, I'm going to go meet Mr. Wheeler and show him my place. I'll stop.
Okay. I'm sure folks have questions for you.
Sure.
Anyone? Please.
Sure. So thank you for being here today and telling us about your situation. Our information packet says that as of June 18th, the ad was still posted.
But I wouldn't, it's just because I wouldn't allow anybody to stay there. I just didn't shut it down because I wanted people to, I haven't used it since April.
Your last stay was in April?
Uh-huh.
Okay.
We do show a stay here that's dated May, but are you quite positive you didn't have a woman named Audra stay with you in May?
No, I'm not positive. She could have stayed there.
Okay.
She could have stayed there. I was out of the country the whole month of May.
So, as Sean just mentioned, the ad, I guess you're saying, is even up today.
It is.
And
I was
while-
told no bookings the month of June, which I've not done.
I actually, what you were told was that you were to remove the ad or change the calendar to a 30-night minimum stay. That's right here. And that is
Okay,
what we're
well-
that is one of the things we kind of look at
Okay.
for, I understand your position is
Uh-huh.
that you tried to do everything to right the wrong.
I did.
That is front and center what you're asked to do when you're found to be in violation.
I am so sorry.
So that is not helpful to us. I mean, that you're in violation today because you have that ad up. Even if you haven't accepted a booking, you are in violation today.
I'm sorry.
Okay. Just so you understand
Okay.
where we're coming from. Anyone else?
That's, again, ignorance.
They do put it right
They
there.
did. I can't deny it.
Yeah, okay. Anyone else have any questions?
It's just, I could say more, but I'm not going to.
Well, you've
No,
told
I'm
us
not
your whole
gonna say
situation and we
anymore.
totally understand.
I'm not going to say any more.
I'm about to close the hearing, and then you won't be able to say anything more, but let me just make sure Mike doesn't have a question. Nope, you're good. Terrence, nope. Okay, we are gonna close the public hearing. You can turn that microphone off because we're not going to hear from you again unless we reopen the public hearing. But for now, you're welcome to go back to your seat. We're gonna discuss this amongst ourselves and decide how to handle this case. Okay. Go right ahead.
So, I mean, this looks like a case where we've got a good operator, we've got a lot of good feedback from their neighbors. The only letter in opposition was more of a general objection to Airbnbs from a neighbor who has a problematic Airbnb across the street. So, that puts me in the camp of relief, but that's tempered by the fact that, it's pretty clear that we're talking about advertising or operating, and that, the ad remains up today. Again, aside from those circumstances, I'm inclined to offer relief, but it's again tempered by that, so I don't know what the right place to land is, but open to hearing from others.
I'm somewhere between complete relief and complete relief and no relief.
Really?
Yeah.
What other
Right.
choices are there?
Well, right. As you said, correct.
I agree. This is a good operator. This is also when people talk about the kind of Airbnb they want in their neighborhood, this is exactly what they mean. It would disturb the owner far more than anyone else if this was a problematic Airbnb. But we count the day of the last violation. Today, she's still in violation, so that it's tempered. So I'm open to some relief. I'm not open to saying, super, tomorrow is a good day, because today she's in violation.
Yeah.
So Nicole always has an idea. Tell us.
I would suggest 2 months from today, because to me, I know that advertising is a violation of the ordinance. To me, the more problematic violation of this ordinance in particular is clearly operating. And that is, I think, reflected in, that's not me making a policy decision or a legislative decision, not a legislator, but that is, I think, reflected in the factors that we consider when we determine what kind of relief, because it talks about, injury to neighboring properties, remedial action, intent, and a lot of the ordinance is all about how you're affecting your neighbors.
Sure.
Operating is far more, neighbors are far more affected by operating than by advertising.
True.
So I would suggest 2 months from today, simply because there's already been about a month and a half of no operation. And so that would be a total of 3 months. But I'm just throwing that out there.
Sean?
So I don't know that I'm super comfortable with going to a sixth of the 1 year wait. I would feel more comfortable with a quarter, so that would be 3 months.
Yeah.
I figured that's where we would get to. So I started
Were
at
you
2.
negotiating?
Yeah.
4 is actually my thought.
I'm going to back Sean on this, and I agree with you. There has been kind of a month's wait, but there was also another failure to abide by the request, which was stop activity now. And, I get it. You don't want to cancel people who have booked for this upcoming weekend, but you're supposed to.
Right.
So-
I think for me, that operation is tempered by the notice of violation that she got that says stop in 30 days.
That is a little
Yeah.
ugly, isn't it? But I think 3 months is still quite kind.
3 months from today, is that what people are? Okay, I'm not going to make the
If the
motion,
ad
but
comes down.
yeah, I mean, she would have to be,
Or change
or
it to
else she
30
would
days.
get another notice of violation. And
What do you
anyway,
think? 3 months from today, presuming that the ad either comes down or gets changed to a 30-day rental starting today?
But how do we verify compliance with that?
We can't.
Codes will verify compliance with that. They'll get her on their list next month if she keeps the ad up. Am I correct in that, Mr. McBroom?
Yes, ma'am. In fact, Metro's compliance contractor, Veronica's Host Compliance, has that information, and actually it's readily available on the website advertisement itself. If you just go to the calendar and attempt to book, it will say a minimum 30 nights.
Right, thank you.
So in the event that she does not comply, it comes back before us, and then we vote
Well,
again on whether to revoke the previous?
It would go through codes, and then if she,
We have this.
I have a feeling after hearing all of this,
Yes.
that there will not be a compliance issue. But I would hope that that would be the case, so.
Look at me and Nicole agreeing. What do we think? Is that? Yes, you can make a motion.
As a non-voting member, can I make a motion or no?
You know, I'm going to say no, because you're not
Okay,
a
that's
voting
fine. So we just need a motion.
I'm sorry.
Okay, then, I would move that, I would move that we grant Ms. Madden partial relief and allow her to reapply 3 months from today.
Do we need to still move that we don't find that the zoning administrator erred?
I think to make it complete.
Yeah.
Because
I
in
don't
accordance
need
with
to
like,
always
because you're
correct your
mitigating
motions.
the
You
penalty.
You guys have to correct mine.
Yeah, I've corrected people's motions before. This is a mutual motion correction society.
Do you want to go again?
Sure, absolutely. I'll make a motion that we find that the zoning administrator did not err in finding that Ms. Madden operated with an expired permit, but that we grant her relief by allowing her to reapply for a short-term rental operating permit 3 months from today's date.
Second. Can I see a show of hands? All voting members unanimously agree. Can I have that? Okay,
Fantastic.
terrific. You're going to take that up with staff, okay? Thank you. Okay, next case.
Okay.
No. Oh. Wow. That was pretty gosh darn nice. So,
That is nice.
can't please all the people all the time.
Oh, she was there?
Pissed, to quote her. Okay, we could go back to 12. Let's move on.
Well. okay.
Wow.
All right.
The next case before the board is 2025-009. This is 7357 Sugarloaf Drive, Martin and Julia Dempa. The permit application is denied. The property operated as a STRP without obtaining a permit. This is an RS10 zone district, and it allows only owner-occupied permits. This is governed by BL 2020-187, and the board has discretion under BL 2023-136. On May the 28th of 2010, Mr. Martin and Miss Julia Adampa acquired the property at 7353 Sugarloaf Drive. May the 30th of 2024, Mr. Martin Adampa acquired the property at 7357 Sugarloaf Drive. These dwellings are on adjacent lots and are pictured in the summary. Metro's compliance contractor, Veronica's Host Compliance tracking shows Airbnb advertisement for 7357 Sugarloaf Drive was first posted on January the 13th of 2025. Subsequently, a VRBO advertisement was posted on January the 26th and a Booking.com ad on January the 28th of 2025. The tracking also shows 8 documented stays in February, 5 documented stays in March, 3 documented stays in April, and 2 documented stays in May of 2025, which we were able to substantiate with 14 reviews on Airbnb website ad and 4 reviews on Booking.com ad. On April 11th of 2025, the address for this property appeared on the monthly list for April provided by Veronica's Host Compliance of properties operating without an STRP permit. Inspector John Feltz verified that the advertisement remained posted with new reviews and sent the notice of violation to the appellant. Mr. Adempa submitted an owner-occupied STRP permit application. The application lacked some documents that were outdated. On May the 1st, 2025, the requested documents were provided. The application was reviewed by Inspector Robert Osborne. Inspector Osborne reviewed the Veronica's host compliance tracking for the property and found that it had already been operated without a permit. Therefore, the application was denied, and Mr. Dimple was informed that the Metro STRP ordinance requires him to wait 1 year from the date of the last STRP activity to apply for a permit. Under 6.28.030.A.5.L, denial or revocation, section 7.2, upon determination of the zoning administrator or the zoning administrator's designee that the short-term rental property is operated without having obtained a permit, there shall be a waiting period of 1 year from the date of such determination by the zoning administrator or designee for the property to become eligible for an STRP permit. On May the 2nd of 2025, the appeal was filed. On June 24th of 2025, Veronica's host compliance tracking shows that there are 4 additional documented stays in May, 3 on Airbnb and 1 on VRBO. Airbnb also has a documented stay in June of 2025, has a stay in June of 2025.
Okay. Great. Any questions for Metro before we hear from the appellants?
I have one question.
Go.
Do we know if the advertisement is still posted?
As of yesterday, it was.
Okay, thank you.
And still posted as a short-term rental or 30-day? Do we know?
I'll be happy to verify that for you. Take me just a moment.
Thank you.
Thank you.
And are Mr. and Mrs. Adampa here? Come on up. It's up to you entirely. You can both speak. One of you can do all the talking. That's how it is in my house.
Do we have anyone in opposition? Do we know? Do we ask?
Well, I haven't asked yet.
Oh, okay.
Nope. And no one is here in opposition to this case? Okay. We're not ready just yet, but when we get started, you'll have 5 minutes to share between the two of you, or one person can have the whole thing. Don't feel like you have to use the whole 5 minutes either, but I'll let you know when we're ready to hear from you.
And then, Chair, while we're waiting, if you would be so kind as to remind folks to, if they want to have conversations, if they could have them in the hall, that would
Yeah.
be great. Thank you very much.
That was distracting, was it not? Yep, while Mr. McBroom looks that up, if anyone has side conversation they need to have, I don't know if you were all privy to what just happened, but let's take them out into the hallway. Out into the lobby and not in this hallway because the sound does kind of funnel back this way.
The advertisement remains posted. The calendar's blocked.
The calendar's blocked. Okay. Good to know. Okay, great. So folks, there's a microphone button in front of you. Press it one time to open. And once you do, give us your name and address for the record and tell us about your situation. And again, 5 minutes or less.
Okay. I'd just like to open up with a statement. My name is Julia Adampa. The address in question is 7357 Sugarloaf Drive, Nashville, Tennessee.
And that is your address, correct?
Yes, ma'am, it is.
Okay, great.
And this is my husband. You want to, or I can introduce you. I think it's this one.
Yeah, and my name is Martin Adampa.
Nice to meet you. Thanks for coming in. Go ahead and tell us about your situation.
All right, thank you. Dear short-term board members, We want to extend our gratitude to your team for allowing us to appeal the denied request to obtain a short-term rental permit. Our property is located at 7357 Sugarloaf Drive, and it's located in the great city of Nashville, Tennessee. We have lived in the beautiful city of Nashville for more than 25 years. Our daughters were born and raised in Nashville. They attend university and metro schools here in Nashville, Tennessee. My husband and I have worked in healthcare, and I also work for Metro Nashville Public Schools. I'm a licensed registered nurse and also do product management, and my husband is an IT professional. We both have a passion for providing Southern hospitality. We love to entertain and make people feel comfortable and right at home. With that said, we pursued becoming business and property owners. Our goal was to launch a B&B and eventually retire from our jobs. In January of 2025, and prior to launching the B&B, we were able to obtain and pay for the following documents to operate as a legal business entity in the state of Tennessee. We obtained our EIN, our business license, our articles of organization for the Secretary of State, the Tennessee Taxpayer Access Point. For reference, we did attach all of these artifacts to our email. After we obtained the artifacts listed above and thinking we were done and ready to open our property for business, we launched our B&B. During that time frame, we were completely unaware that a STR permit was required to operate. The hosting platforms did not mention that a STR permit was required to list our property. It was displayed to us as optional fields to complete. Thus, we left those fields blank on the hosting platform and was able to proceed and build our hosting profile. We sincerely apologize for this mistake. We are presenting this to the STR board to bring our property into compliance with Metro codes so that we can fully operate in Nashville as a B&B. Our property serves as a primary source of income for our family. Our property serves as a peaceful haven and escape for guests looking to relax and enjoy time away from work and the daily grind of life. I would like to reiterate, we were unaware of the STR permit requirement until we received the letter from Metro Code stating we were operating without it. Then we rushed to get an STR permit application turned in, but our request was denied by Robert Osborne on May 1st, 2025. After Metro Codes denied the STR permit request, we did unlist or block on all platforms that we were on. And we're looking to be in compliance today, pay the fee for the STR permit, and continue operating as a short-term rental here in Nashville. We just want to be in compliance. That's why we're here. And I did say in my statement to Alicia, I think I said to Alicia, that my husband was supposed to be out of the country today to attend a funeral, but he decided to come here and support me in this, so he's here. Because this is important to us.
Sure.
This is important to us.
And I just want to add one more thing to that. I know we did not on list, but we blocked the calendar. However, we did have individuals that had booked the property all the way up until November. So we just don't know if we need to, tell them, which we don't want to, because they already paid it on the platform.
Understood.
And, this is our first time. So I just want for you guys to be aware of that.
We understand. Okay, anything else?
We're just excited. I just want to say we're just excited to be here. I watched some of the previous sessions and I was like, wow, this is really interesting. But yeah,
You're the first
point,
person to say that.
yeah,
It's great.
yeah, because we want to be in compliance. That's why we're here.
Understood.
That's why, yeah.
Great. We are probably going to have some questions for you. Yeah? I'll start then. Can I just clarify, you said that when you set up your profiles on the short-term rental sites, there was a segment that your permit number was to be entered, but it wasn't required?
Exactly. Exactly. It didn't say, oh, you're in the state of Tennessee and Metro Code says to enter your short-term permit because it's required. It was optional.
Yeah.
So we didn't think, oh, hey, we should probably apply for a permit. We didn't think that. We were like, let's get it out on the platform.
And you've never owned a short-term rental in this city or any other city?
That is an accurate
correct.
statement, right?
Okay.
Yep.
And I understand that you pursued a business license. I have a big packet here, and maybe I'm just missing it, but has anyone else noticed the business license in the packet?
Not in our packet, but I think that she was saying they sent it to codes for their
Okay.
application.
Okay, okay.
Is that,
That's correct. I have documentation here if you
Sure.
need to review that.
got it, thank you.
Can you tell me when the business license was issued, if you
Yes.
happen to have it handy?
Absolutely. One moment. I got a lot of things here, so. Okay. You just need, I'm sorry, did you just need to know the date or do you need to see the,
No, just the date is fine.
sorry, 150. So it says it says start date 1/15/2025. And it the license expires 5/15 of 2026. Does that help? So the issue date was 1/16/2025.
Perfect, yep, that helps a lot.
I do have a question if you're
Oh.
done. Have you had any feedback from your neighbors, any conversations with them? Because I didn't see any letters in support or opposition, but just wondering if you've had communications with your neighbors.
Oh, absolutely, absolutely. Our property is, like I said, it's a haven. We actually talked to our neighbors before we decided to go into the SDR business. And they always come by and say, hey, you guys are really bringing in really good guests from out of town. You're looking at the cleaners, you're looking, the house is right next door to our home, okay? And I think you guys may have had that in your documentation. But it's a peaceful neighborhood, and like I said, we love hospitality, and that's what we're in the business of right now, so.
And also, just to add to that, prior to us obtaining the business license, before we did anything, we spoke with the association, the
Yeah,
homeowners
we had an
association.
in-depth conversation with our HOA.
Yeah.
Because we have not seen an SDR in our neighborhood before. So we were like, let's try to do this right, okay? So our subdivision was in a transition period in terms of the HOA association. So as soon as that new HOA association came on board, we had a conversation.
Yeah, we asked for permission.
Yes,
And also part of that was I think either was them or another entity asked us to talk to our neighbors. So
They
one of the
encouraged us
things
to.
that we did was talk to both our neighbors on adjacent sides as well as the neighbors across the street to make sure that if we were to be bringing Airbnb, would they be willing or are they okay with it? So we did that and they all okayed it. And I think that was part of
right,
I don't know
that
if-
was part of the short-term rental packet or online application or some, you know what I'm talking about.
And then we
But
send
were
all
able
that
to
in.
notify the neighbors and talk to them.
And so let me just correct this for the record, because this was at the top of your statement, I said that is your home.
Yes.
So you were talking about the address in question, because that is 7353.
57.
7357 is the Airbnb.
It is,
Correct.
yes.
And 7353 is your home.
Correct.
So you live there. So
Yes.
this is a non-owner occupied, and that's permitted in this zone.
It is owner occupied.
I don't think that's before us, but
No,
This is
Yeah.
an RS10 zone, so no, only owner-occupied permits are available.
That's something they might want to talk with staff about after we consider
Yeah.
the matter before us.
so we're gonna get to that, unfortunately. What other questions do folks have for the Adampas? Okay. we're going to discuss this amongst ourselves. You'll hear everything we're talking about, obviously. The public hearing is going to be closed, so unless we have other questions for you, we won't give you another opportunity to speak. If we do have questions for you, we will reopen the public hearing and we can talk. But I have a feeling you're going to want to talk to staff after today, okay? So thank you very much for your time. You can close the microphones. Just press it once. Thank you. You can return to your seat. There we go. Okay. You're so welcome. Oh,
Well, laying aside
Yes.
that last minute wrinkle, I think this one bears a lot of factual similarities to Ms. Madden's
Yes.
situation.
Agreed.
So I would think that we would be sort of looking in the same range in terms of relief to offer.
I think the difference for me, oh, sorry, I need to.
yeah, no, it's fine. Go ahead.
The difference for me is that they still have upcoming stays that they haven't canceled because they were waiting to hear about this, which I understand from a financial perspective, but from a compliance perspective, it is not.
I think that could arise from the same confusion that led Ms. Madden to believe she can continue to advertise
Yeah.
when the notice of violation was clear and said you may not do either of these things.
And just for the kind of the facts of the case, it's like, I think there is a difference between letting a permit lapse and never having a permit to begin with.
Yeah,
as well.
that's kind of
Agreed.
where I was going to go.
Yeah.
Ms. Madden had a permit for 5 years and
That's
dropped
true.
the ball after renewing it 4 times.
That's true.
And
So,
there, oh, sorry, go ahead.
I kind of feel like the business license thing kind of negates,
Right.
the intent was to be
In compliance, yeah.
compliance.
Yep.
They just went the wrong route.
Yeah.
So I am more than happy to offer relief. I just don't think it's going to serve them well.
Well, and
that-
that's-
yes,
and
yeah,
that's not our
But, right,
Right.
yes, but I agree with you there. I think that if we can accept, a claim of innocence in the previous case, I think we can accept one with this one. There was a mistake of fact, both fact and law. Or there was a mistake of fact, regarding whether or not they had satisfied all the legal requirements for operation of an Airbnb. So I don't find there to be great enough distinction to rule much differently than we did in that case.
Can I just offer one counterpoint to that?
Sure.
In the ordinance that governs this permit, there is a distinction in the ordinance about the amount of time penalty if you have operated with an expired permit is 6 months versus if you operate prior to obtaining a permit is 1 year. So I think the council intended there to be a difference, a factual, like they saw an important distinction between those two, and they wrote the ordinance to that end.
Right.
So I would feel comfortable, again, I don't think it's going to matter, but going through the motions, I would feel comfortable with something more in the range of 4 to 6 months, simply because they still have listings coming up, and the council intended there to be a heavier penalty for people operating prior to obtaining a permit. I realize I'm on the opposite side of where I usually am, but.
Yeah, I think
And
the
I'm-
intent is to
yeah.
avoid compliance.
Since the legislative intent was brought up, thank you. I want to note that there's a life safety component to that initial issuance of a permit, the fire inspection. There is some substantially important aspects of that, aside from just compliance.
Understood.
The life safety issues specifically.
Yeah, I think for me, it comes down to, is this a case where, sure, we can concede that there is operation without a permit, that's not in dispute, but was it because there was an intent to avoid application of the statute? Was it a knowing intentional, or was it was it born out of ignorance? But I think Ann actually had something that she wanted to contribute.
Oh, just to clarify, the ordinance was updated, and the prior case was, I believe, under a previous form of it. We shouldn't make a distinction between like failure to renew and or not operating
Yeah,
without a permit.
sure.
So just clarifying that, because there was a difference in the code, and that got changed. As Nicole rightly noted, the council did change depending on the circumstances, so whether
Yes.
or not you failed to renew or just never had the permit at all.
I can certainly acknowledge the fact that the council did make changes. I think there are mitigators here, just as there are mitigators there.
Would you like to maybe someone make a
Let
motion?
me just make sure Mike doesn't have. Is it because you're so isolated down there? You can come down here. Yeah, somebody make a motion because I
Okay.
think we're gonna.
Well,
end up in
then
the same
I will
place.
make a motion that, we find that the zoning administrator did not err, but offer the Adampas relief, partial relief, and allow them to reapply, other issues notwithstanding, 3 months from today's date.
Second,
Are you calling for a second, or are you seconding?
I'm seconding. I know it sounded like a question.
Okay.
I just don't know how successful that's gonna be. Can I see a show of hands for 3 months?
Okay, well then,
That motion failed.
okay. Is there an
Shall we,
alternative motion?
shall we try again with a different number? Go ahead.
I'd make a motion to find that the zoning administrator did not err in determining that the property operated as an STRP without obtaining a permit, but given the mitigating factors, that we would offer relief and that the Adampas could apply for a permit 5 months from today.
I'll second.
All right. Okay. Can I see a show of hands on that motion? Okay. So that was unanimously agreed upon by all voting members. So, Mr. and Mrs. Adampa, I'm sure you just heard that. There's a separate issue that is not before us today, that you're going to have to address with staff about what kind of permits are even permitted in your neighborhood. So that may make a lot of this a moot point, and you're going, 5 months from today, you are allowed to apply for a short-term rental, but I would highly suggest that you consult with staff about what is permitted in your neighborhood in the first place. Okay? So thank you so much for your time today, and we wish you all the best, okay? Okay. Moving on.
The next.
Mr. Spurko, Ryan Shaw Spurko?
Is there opposition to the case?
Okay.
All right, so this is 2025-011, 1023 10th Avenue North, Mr. Ryan Shaw Spurko, permit revoked. The STRP is not the principal or primary residence of the owner or appellant. This is an RS 3.75 zone district, and it allows only owner-occupied permits. This is governed by BL 2017-608. The board has discretion under BL 2023-136. On June the 15th of 2016, the appellant, Mr. Spurko, acquired the property at 1350 Rosedale Parks Boulevard, number 417, Nashville, Tennessee, 37208. On April the 8th of 2019, the appellant acquired the property at 1023 10th Avenue North, Nashville, Tennessee, 37208. On April the 10th of 2019, an owner-occupied STRP permit application was submitted for 1023 10th Avenue North. And on May the 3rd of 2019, the permit was issued. On January the 16th of 2024, a request for service came to the office through the Hub Nashville for 1023 10th Avenue North, which read as follows. Short-term rental compliant description, permit number 2019-020758 is filed as an owner-occupied and is not owner-occupied, where the owner does not live here and holds a primary residence as confirmed on an alternate permit LL 2023-26269, where the same owner is listing their primary address elsewhere. The owner is illegally and under false pretense renting the home as a short-term rental, and it included the link to the website advertisement. This complaint was initially sent to another division of the Department of Codes and Building Safety. It was not received by our office until February the 12th of 2024. February the 8th of 2024, another request for service for 1023 10th Avenue North came to our office via email that stated that the website advertisement for the property did not display the permit number as required by the STRP ordinance. Inspector John Feltz verified that the complaint was valid and a notice of violation was sent to the appellant. February the 12th of 2024, the first request for service was received by our office. Inspector Phelps opened an investigation as to the true primary residence of the appellant. He looked up the landlord registration that was mentioned in the complaint and found the appellant's address listed as 1350 Rosedale Parks Boulevard, 417. The deed for 1350 Rosedale Parks Boulevard, 417 lists the owner as Ryan Shaw Spurko with the address of 1350 Rosedale Parks Boulevard, 417. The Metropolitan Assessor of Property lists the owner as owner of 1350 Rosedale Parks 417 is Ryan Shaw Spurko, and the owner's address as 1350 Rosedale Parks Boulevard 417. The Metro trustee lists the owner of 1350 Rosedale Parks Boulevard as 417 Rosedale Parks Boulevard number 417 is Ryan Shaw Spurko with the address as 1350 Rosedale Parks Boulevard 417. The deed for 1023 10th Avenue North, Nashville, Tennessee lists the owner as Ryan Shaw Spurko with the address as 1350 Rosedale Parks Boulevard 417, and the Metro Property Assessor lists the same for 1023 10th Avenue North. Metropolitan trustee lists the owner of 1023 10th Avenue North as Ryan Shaw Spurko with the address as 1350 Rosedale Parks Boulevard 417. The deed of trust for 1023 10th Avenue North has a 1-to-4 family rider, which waives the occupancy requirement contained in number 6 of the Uniform Covenants of the Deed of Trust, which requires the borrower, Mr. Spurko, to occupy the property within 60 days after the execution of the Deed of Trust and to continue to occupy the property as the borrower's principal residence for at least 1 year after the date of occupancy. The 1-to-4 family rider is the last 3 pages of this document. Section F waives the number 6 of the Uniform Covenants occupancy requirement, and Section H contains the assignment of rents. The appellant has 2 registered vehicles, both of which are registered at 1350 Rosedale Parks Boulevard, number 417. Our office was sent a 2025 Warden Lofts Phase 4 and 5 board candidacy form that was submitted by the appellant on March 16th of 2025, bearing his signature, in which he states that he currently lives at 1350 Unit 417 and has since June of 2016. And I quote, "I have served on the Worthing Phase 4 and 5 board multiple times already, including some of the most challenging times." And another quote, "My only investment at Worthing is my personal residence." The Worthing Lofts Phase 4 and 5 is located at 1350 Rosedale Parks Boulevard. Please refer to the printout from the Worthing Lofts Facebook page near the end of the case summary. Based on the information and evidence outlined above, the decision was reached to revoke the owner-occupied STRP permit for the appellant's property at 1023 10th Avenue North. The revocation letter was mailed to Mr. Spurko at both 1023 10th Avenue North and 1350 Rosa Parks Boulevard. The letter informed the appellant that the revocation would take effect on April 24th, 2025. April 25th of 2025, the appeal was filed. There were 2 complaints that came in on the Hub Nashville, which were described previously, and there were no complaints on the STRP hotline, and there were 2 letters in opposition to granting the appeal.
Okay.
And the zoning administrator would like to add some.
Thank you. Good afternoon, board members. I don't know if I'm going to add much to it, but you may be. Oh, I'm Joey Hargis, the Metropolitan Board of Zoning Administrator. Excuse me. I got my BZA hat and my zoning administrator hat just bounced together in my head. I'm Joey Hargis. I'm the Metropolitan Zoning Administrator, and I serve as staff for your board as well as the Board of Zoning Appeals. But I don't know that I've got terribly a ton to add, but I do want to kind of give you all a heads up. I'm going to make some more appearances, especially on cases of residency. These are a point of emphasis for me and my staff. You've had cases here. Last meeting, we had a husband and wife discussion of where they live, and Ms. Williams, I'll tell you at least this one: there's no donkeys involved in it, so we don't have to worry about livestock or any of those kind of factors in this case.
Donkeys were very compelling.
Yeah, I don't believe the gentleman has any livestock. So that was a discussion at our last case. Yeah. But I do want to make a point of emphasis that I will be making more appearances and depending on the facts of the case, I may vigorously advocate that you all not uphold a permit. So, and I do so and I've told Metro Legal to lay the groundwork for potential litigation if it becomes necessary. The council has got to act to fix this ordinance. So this message, Mr. Parker and the 39 other colleagues, this ordinance has got to get amended. The language in it leaves some ambiguity, which is left to me to determine. But just some things, and we'll talk about in a prior case, that, husbands and wives, spouses live together. They could both have houses, but there's only going to be one place. So not to get off the tangent with Mr. Spurko's case. His case, and I just wanted to provide an opportunity to give him to rebut that it was just when my staff comes to me for every revocation, especially when it deals with residency, we go very detailed. We have just a signed staff meeting every 2 weeks to go over all these cases. So in his particular case, I just looked at the weight of the evidence. It just reasonably, there was just too much one way or the other that pointed to Worthen Loss being his location. I know he'll testify that we don't have to live there to be on the board, and that may be the case. I don't dispute that. I'll trust you on that. But just some of his, like Mac had read, some of the statements by the applicant that he's a resident there. I couldn't pass up the weight of
Very good.
of that. So
Any questions for Mr. Hargis before we hear from the appellant?
thank y'all.
Okay. So, in this case, we do have opposition.
Okay.
So you will have 10 minutes. Press it one time with feeling. There you go.
Okay.
So, just to make sure that we're clear, you have 10 minutes because you're going to want to save time to rebut what we hear from those who are here in opposition. So don't use your whole 10 minutes up front, and please don't feel like you need to use the whole 10 minutes if you can share your experience with us in 5 or 4.
Yep.
And that is about
Before I start,
it.
I have some information packets, if I can share those.
Where do we stand on that at this stage? That's yes if you have enough for everyone, right?
I do.
Okay.
And we have the opportunity to defer if we want to, if we
One
feel
for
we
each,
need
yes.
more time to consider the documents provided.
That is correct, under your Rule 5D.
Shall I assume that you are going to summarize some of
Yes.
what's in this packet during your allotted 10, hopefully less than 10 minutes?
Yes, I'm
Okay.
going to move quickly, and I'm going to walk us through
Okay,
the information here.
well then, I am comfortable taking this packet without deferring the case. Is everyone else?
Can we make that decision?
We can
You can make
Okay.
that
We can make
decision
it
at any
after.
point before you call for
Okay.
a vote.
Okay.
All right,
Okay?
okay.
All right, I'm going to start my clock. All right, so good afternoon, everybody. Thank you for taking the time to listen to my case today. My name is Ryan Spurko of 1023 10th Avenue North in Nashville, Tennessee. So I've got 2 pieces here. I want to start by giving a history of my purchase and residence at the property at 1023. And then I also want to speak to my secondary residence at Worthen Lofts, because that seems to be a point of the original contention of my short-term rental permit. So starting with the 1023 10th Avenue North, the property was purchased in April of 2019. I moved in shortly thereafter and received my short-term rental permit in the month of May 2019, at which point I listed it. When I looked at the packet that I received last night, I was a little bit concerned that I saw 2 letters in opposition, but as I read them, I saw they were kind of general statements against short-term rentals in my neighborhood. So I want to share a little bit of history on some things that happened within a neighborhood. Before I get to that, though, I just had some documents that were both used when I submitted for my original permit, and that still remain the case. So it is my primary residence. I do reside there. My driver's license is there. You can see some bank statements both before and after I received the notification to show that I just did not change that for this. My personal income taxes are filed there. And then you get into a page that has some screenshots of messages going back and forth all the way back to 2021, the years of 2021 and 2022. So when I first moved in, the house next door was an abandoned, rundown, collapsing red house. It was home to some homeless. There was drug activity going on. Doing some research, we found out that the house had been abandoned. It was supposed to be knocked down many months before by the city. That had not been done. So my girlfriend and I at the time, we took a lot of steps in order to make sure that that house got removed because it was both an eyesore and a danger to the neighborhood. Well, shortly after it was removed, an investor bought that property next door. They were going to develop on it. Went through some permits, had to dig a hole to put a water pump in there. That got halted. We were left with a big hole in the ground. I pushed, again, very hard to have the lot next to my home, have that protected. So worked to have a fence put up around that. Long-term, got that filled in. And now, if you look at that second page of pictures, the bottom right corner, that's the property as it current stands. So, I feel that I've done a lot, both to contribute back to the neighborhood and to protect my home, the people that come in and out of my home, as well as the neighbors in the neighborhood. In addition to that, out of my own pocket, I have paid to have furniture removed and debris removed in the alleyways that the homeless tend to set up secondary homes when I've failed to get response quickly from the city. The next 3 pages you can look at your own time. I won't take my time, but those are some letters from both my direct neighbor next door and a couple of neighbors in the neighborhood, which I speak to, interact with, and we kind of keep an eye on each other's properties because I do travel a lot. And then finally, one of the pictures, the notes that came was from a house down the street, 914 Phillips Street. I took a little field trip down there. They were claiming that there were issues with what they saw from my property as they exited their house. The way the alley is set, they're about 750 feet away. You can't even see my house. And on the bottom are the pictures of their next door neighbor, abandoned property in the back and broken out windows. So I kind of questioned, is it really an issue, or are they taking a stance just to go against short-term properties? Now I'd like to quickly shift over to the property at 1350 Roselle Parks. That is a condominium. That was my initial purchase in Nashville, where I initially lived until I moved into my property on 1023 in 2019. I decided to keep that property. It's an investment. It also serves as a remote office. So if I have guests that are staying in my home, it allows me to go stay there. When I am working, it allows me to go work there. As was mentioned before, yes, I have been on the board before. I ran on the board again. I have an interest there because of a property there. It's a secondary residence. It's a home office. Call it language in that bio. I said it is a residence because it is. It's a secondary residence. However, it's not where I call home or I maintain permanently. Some additional information I kept in here to also share with that case. In 2019, and I believe it's the last sheet, I actually did consider renting out that property long-term because I was not living there full-time and crashing there. And I actually did file for a permit to do so. But a few months after that, my personal business grew and I established my company called Autonomous Business LLC. And the condo, secondary residence, became the mailing address or the office, so to speak, home office, expanded into the business office for that, which, I mean, that we don't have people there, it's just me using it. But that is also why my vehicles are registered there, because they're work-related vehicles and they become a tax write-off. So that is why that's the case. And then you'll also see in the second to third last sheets, we did have our monthly board meeting last night, and a couple of the board members did offer to also write letters stating their case that I am not there full-time. It is my secondary residence. And again, I don't have to be a full-time resident there to be on the board. So I ask you to consider this information. I've been a long-standing short-term rental owner. It's a beautiful house. I am very careful who I let live there. I respect the neighborhood because it's a nicely furnished house. My stuff is there, and when my guests leave, I enjoy hosting and showing Nashville. It's my stuff and it's my home. So I think that is also why in the 6 years you've never seen any noise complaints or issue complaints through the short-term rental. One final piece, we've had some owners that disagree with the board, and they've taken upon themselves to attack us individually, and I can only imagine that is where this stems from. Not even residents of the neighborhood where I'm at, given that nobody else would have seen that bio aside from owners that were the North. Thank you.
Hold on one second. Alicia, how much time did Mr. Spurko? Okay. So before we ask you any questions, and your answers will not eat up this time, just
Okay.
keep in mind that when you are given time to rebut, you only have 1 minute and 45 seconds left.
I'll be succinct, thank you.
Okay. Nicole has a question for you.
Hi, so I'm a little confused about your statements here today and your application that we're looking at for the board at Worthen. Today you said that Worthen is your secondary residence and a home office. In your application, you say, my only investment at Worthen is my personal residence, and more instructive for me, my properties outside of Worthen are rentals. Could you explain the
Yes.
difference
The biggest point of contention, and really one of the reasons that I was asked to run and rerun for the board has been the issue with rentals at Worthen. So we are supposed to have a 30% cap on those that rent at the condo complex, and that was far exceeded. And many, or not many, but those that were attacking the fellow board members and the property managers, it was due to that cap. They were above the cap, they were illegally renting, they did not have permits with the County of Davidson, so they were breaking the bylaws as well as the rules of Davidson County. So, poor use of language for me. I wanted to make it clear that I was not renting my condo at Worthen, that it was a residence, and that the rumor that I was a renter and did short-term rentals were properties that were outside of the condominium complex. So I wanted to very clearly distinguish that, never dreaming that somebody would use it maliciously against me. So I guess in hindsight, it was poor verbiage or pick of language in establishing that bio in the attempt to make it clear to the fellow owners there and the voters.
Okay, and then, in you said in 2019 you were considering renting out that property. Which property were you talking
It
about?
was 2023. So 2023 was when I was questioning, hey, do I still need to keep the secondary residence, the home office at Worthen? And I believe it's the very last page. That would be at the time when I was considering that, the permit that I did file with Davidson County to be able to rent the property
Worthen
at
property.
Worthen
Okay.
full-time, right? And I was going to go down that path until the opportunity to establish that as home office and have the tax opportunities there veered me to keep it.
I just have one more question.
Okay.
I'm looking at your driver's license that you provided, and I see the address is 1023 10th Avenue, but the issue date was October of 2024. What was the address on your previous license?
It was the same. It was 1023 10th Avenue North, and I can provide evidence of that. It was the one that I originally received my short-term rental permit with.
Okay, thank you. That's all I have for now.
Yeah, it expired, so I had to get a new one.
I mean, I realize Nicole's already asked you this, but it just seems like a very pointed piece of information. My only investment at Worthen is my personal residence, as opposed to my property at Worthen is not rented out. My property at Worthen is my home office that I take advantage of Monday through Friday when I'm in Nashville. But also for the 2025 questionnaire for prospective board members, do you currently reside at Worthen Lofts? Yes. If not, where do you live? Not applicable. I mean, it's not really, there's not a lot of wiggle room there, right?
Again,
I mean, you can certainly understand why the zoning administrator,
yeah, and I don't fault the zoning administrator at all. I mean, again, the language was unfortunately picked for that bio based on the hot topics that were taking place within the condominium. And again, like I said, hindsight, I would have, stated it more concisely, more clearly, and separated the two more.
any other questions? Because we do have quite a big agenda today. We do have opposition to hear from, and we still have a minute 45 to let Mr. Spur go.
I just wanted to clarify one thing, that we take the cases that come before us. We don't interrogate the intentions of the people who are raising issues. Just as a
Right.
clarification, we take what comes before us.
Yeah. Very fair. Okay, sir.
It's not covered specifically in the rules of procedure for the board. However, I believe the precedent has been set at prior meetings that when we receive material such as this and we review that, I can be recognized to comment.
Oh,
Would you recognize me?
the chair recognizes Mr. McBroom.
I would like to point out that two of the letters from neighbors are Miss Anka Charles, who previously testified at the board meeting that she lives in Gallatin at 880 Farrington Way, if you recall that meeting.
Yeah.
And also, another letter is from Mr. Jarrett Lane, who is on appeal today
Yeah.
for that.
That name did catch our attention, because we will be speaking with Mr. Lane very soon. Okey doke. Thank you for that clarity, Mr. McBroom. Thank you so much, Mr. Spurko. Appreciate your time. You can step back if you like. We are going to hear from the opposition to this case. Press it one time. There you go. And then you'll have a minute 45 to rebut. If you're both here in opposition, you're both welcome to come up. You'll have 10 minutes between the two of you to speak.
He's actually the president of the neighborhood.
Okay.
So I just,
Come up for moral support if you like.
well, I can let you.
Okay. We're going to have 10 minutes between the two of you. If you're both going to speak, we're going to get both your names and your addresses for the record. Don't feel you have to use all 10 minutes, but anything I missed? We're good? So when you are ready to speak, sir, you're going to press that microphone button just the one time. So please go ahead, start with your name, your address for the record, and tell us your observations and situation.
Certainly. My name is Dr. Kevin Griffith. I'm at 1013 Warren Street. I'm the president of the Hope Gardens Neighborhood Association Board. I oppose this appeal for a variety of reasons. One, Mr. Spurko is a stranger to me. He's never come to any of our meetings. We see a parade of new residents or new visitors coming out of that property all the time. As was noticed, the next door neighbor is also an absentee landlord who does not live in the neighborhood. The codes complaints that he mentioned was actually due to my action, due to the neighborhood association's action. We noticed there was a pit that was full of water, it was attracting mosquitoes, it was a hazard. The absentee landlords nearby did not report it, so the association actually reported it, and it was under our hub requests that it got fixed. Also, we brought this up at our last neighborhood association meeting. We discussed this property. We all agreed, including his neighbors from further down on 10th Avenue North, that he does not live there. And we took a vote, and it was unanimous with about the approximate 25 members present that we should oppose this motion on behalf of the neighborhood association.
Sir, please, if you have anything to add.
Sure. My name's Ed Lynch. I live on 1018 11th Avenue North. Just to review a couple of statements made with regard to cleaning trash and being a compassionate neighbor. Kevin and myself, we're a tight-knit community in Hope Gardens and subject to many, many Airbnbs and all that comes with it, from litter, overflowing trash, parties, everything. But in terms of that home, it's very close where I walk my dog daily. The house is vacant at all hours of the day during the week. It looks abandoned for all intents and purposes.
Very good. Before you disappear, any questions for these gentlemen?
I don't remember your name, President of the Neighborhood Association.
Dr. Griffith.
Kevin Griffith.
Dr. Griffith, thank you. You said that there was a vote of the Neighborhood Association, and that there were 25 people there, so you're speaking on behalf of them. Was there anyone in attendance at that meeting who voted against the motion to oppose this?
No, we discussed all of the properties that are on the agenda for Hope Gardens at that meeting. For this particular property, it was unanimous. This was seen as one of the most egregious Airbnbs in the neighborhood because of the lack of interest in maintaining the standards around it and how the neighborhood association had to step in to mitigate the environmental issues next door.
Thank you.
But just to clarify, because the issue before us is that Mr. Spurko may not live there full-time, that is not his primary residence, and all of us as Nashvillians are grateful for neighbors who look out for the standards of a neighborhood and make complaints when necessary to get things cleaned up. So amen to that. But the issue at hand is, does Mr. Spurko live there? And it's your contention as neighbors that that is not the case.
Correct. And some of the members present, I mentioned the next door neighbor is another Airbnb owner that does not actually live at the property. If you go 4 houses down, those members were present at the meeting, and they also were part of the unanimous vote.
Very good. Okay, any other questions? Thank you so much for your time today, gentlemen. Greatly appreciate it. Mrs. Spurko, you have 1:45 if you'd like to respond.
I'll be quick. You ready?
Definitely.
All right, so again, the property next door with the items that took care of it, again, not my property. I maintain my property. I make sure that all of the guests, as well as myself, maintain the trash and everything around my property. And they're right, I'm not there a lot, I travel a lot. I do have one more piece of evidence that I can share that kind of captures that. So just at Marriott alone, I have 115 nights that I have been away this year due to traveling and being at Marriott. I am a 2 million lifetime miler on Delta. I have $19,386 spent on flights because of my work travel, and 13 flights and $26,000 spent on Southwest. So yes, The house may be vacant during the weeks, lights off sometimes, but it's because I'm a road warrior and I've got the data that also shows that. I feel it would be unfair to be ostracized because I have an occupation that takes me on the road, and that also impacts me. And it's another reason why I have the opportunity to rent, because I'm gone a lot.
Very good. Any questions for Mr. Spurko before we let him go? Okay, we're going to discuss this amongst ourselves. Thank you so much for your time. And unless we reopen the public hearing, that is the last we're going to hear from you or from the opposition. So thank you so much for your time.
This one is pretty cut and dry to me. His admissions in his board application, testimony from neighbors, basically the entire neighborhood association. I can't find convincing evidence that he does live at 1023 10th Avenue North.
Karen?
I have nothing to add.
Nothing to add? Sean, anything to add? Mike, anything to add? I have nothing to add. Would you like to make a motion?
Certainly. I will move that the zoning administrator did not err in determining that 1023 10th Avenue North is not Mr. Spurko's primary residence, and therefore this appeal is denied.
I second. Do I see a show of hands? Okay, Alicia, all voting members unanimously agreed. Mr. Spurko, thank you so much for your time. We wish you the very best of luck. Gentlemen, thank you so much for coming in and speaking with us today. All right, thanks all. You're going to speak to... All right, next case.
Our next case is 2025-013, 1000 Warren Street, number 101, Joseph K. Moy. Representative Destiny Klein. Permit renewal denied. Property operated as a short-term rental with an expired STRP permit. This is an RN20 zone district. Now, this permit was issued prior to the January 1 deadline, whereby not owner-occupied permits were not to be issued any longer in any residential zone districts. And so this is governed by 2017-608, multifamily not owner-occupied STRP permit, issued 7/18/2019 in accordance with the State of Tennessee Public Chapter number 972, House Bill number 1020. When the appellant is allowed to apply for a new permit, it is grandfathered, meaning it will be able to apply for and be issued a new multifamily not owner-occupied STRP permit. Under that ordinance, it's up to a 1-year wait based on the determination of the board. The board has discretion under BL 2023-136. On April 18th of 2012, Mr. Moy acquired the property at 1000 Warren Street, 101. On March 22nd of 2018, a STRP multifamily not owner-occupied permit application was submitted. On April the 19th of 2018, the multifamily permit was issued. Permit renewals by email were not instituted until November 1st of 2021. Thus, reminder emails were not sent out at this time. On June the 4th of 2018, our office received an STRP hotline email complaint which read nuisance, trespassing, police not called, no STRP permit number or image in the advertisement. I verified that, and I cited the owner copied the property manager for not displaying the permit number in the website advertisement on that date. On June 18th of 2018, I noticed the notice of violation was returned undelivered to our office, and I posted a copy on the front door of the property. June 25th of 2018, the website advertisement was corrected, and I closed the case. On April the 19th of 2019, the permit expired. On June 19th of 2019, the renewal payment was received after the grace period expired on May 19th, 2019. The permit expiration letter was sent and the renewal payment was returned. I'm sorry, yes, that's correct. And the permit expiration letter was sent and the renewal payment was returned. On July the 5th of 2019, a multifamily non-owner-occupied permit application was submitted. The appellant had not operated after the permit expired and thus was not subject to the up to 1 year wait based upon the determination of the board to apply. As previously mentioned, the issue date for the original permit, which was 4/19/2018, and the grandfathering provision on TCA section 13-7-603 require that both this permit and the subsequent permit be governed by BL 2017-608. Under this ordinance, both operating without having obtained a permit and operating with an expired permit were viewed the same. Thus, the penalty for both was the same. The ordinance section 17.070.U.4.I.1.7 penalty for operating a short-term rental property without a permit shall be, number 2, upon the finding of the board that short-term rental property is operated without a permit, there shall be a waiting period of up to 1 year from the date of such finding for the property to be eligible for a STRP permit as determined by the board. On July the 18th, 2019, the multifamily permit was issued and the permit was renewed in the years 2020 through 2023. July the 19th of 2024, the permit expired. July the 22nd of 2024, Administrative Officer Alicia Buffer sent the following reminder email to the contact listed on the permit, Grand Welcome Property, and to Melissa Ward with Grand Welcome Property Management, who is listed as on the permit as responsible for the billing, and to the appellant, Mr. Moy, which read, your STRP for 1000 Warren Street, number 101, expired on July the 18th of 2024. I'm inquiring to see if you planned on renewing your permit this year. If yes, the 30-day grace period will end on August 18th, 2024 at 11:59 p.m. Please renew. We received no response. On August the 19th of 2024, Administrative Officer Buffer sent the final reminder email to the listed contact, Grand Welcome Property, and to Melissa Ward with Grand Welcome Property Management, and who is listed as responsible for the billing, and the appellant, Mr. Moy, which read, hello, your STRP for 1000 Warren Street, number 101, expired on July 18th of 2024. Your 30-day grace period ended on August 18th of 2024 at 11:59 p.m. Please contact David Frabit at Nashville.gov regarding your expired permit. On both emails above, the email address for Grand Welcome Property Management was incorrect. It was listed with missing an I, but it should have been as you see in your packet. In both instances, it was returned undelivered. This prompted Administrative Officer Buffer to place 3 phone calls to the management company and 1 to the appellant. She was unable to make contact with the management company, but was able to leave a message with Mr. Moy's voicemail. However, Melissa Ward and Mr. Moy were copied on both of these emails. Their emails were delivered. Our office did not receive response to any of the above-mentioned emails or phone calls. On May the 7th of 2025, an email was received in the STRP renewals mailbox from Destiny Klein, the new property manager, inquiring about how to access a permit renewal code. Inspector David Frabit responded that he needed the permit number or address for the property. On May the 8th, Ms. Klein responded 1000 Warren Street, 101. Inspector Fravett informed Ms. Klein that the permit had expired on July the 18th of 2024, and the property had continued to operate. As a result, they were subject to a wait period in which they could not advertise or operate before they could submit a permit application. He also told Ms. Klein that the owner had the right to appeal and to let him, Inspector Fravett, know if the owner chose to appeal. The email correspondence is included in this case summary. On May the 12th of 2025, the appeal was filed. After the permit expired on July 19th, 2024, there were 16 documented stays, 2 in February of 25, 5 in March, 6 in April, and 3 in May of 2025. June 16th of 2025, as of this writing, the ad remains posted and can be reserved for less than 30 nights. There was one Hub Nashville complaint, which was described earlier in the summary. There were no short-term rental hotline complaints, and there was one letter in opposition to granting the appeal.
Okay. Does anyone have questions for staff before we hear from the appellant or the appellant's representative? I know I do. So let me just clarify my understanding that this property was granted a non-owner occupied permit because it had applied before the rule changed about different zoning laws. So if this were to be, if this waiting period is enforced, will the appellant even be eligible?
Yes, under the Tennessee HB 1020, it specifies that what would kill the permit would be for the property to be sold or for the operation to cease for 30 continuous months, which would not be in effect on either of those.
Very helpful. Go.
I noticed that it says the ad was still posted as of June 16th and could be reserved for less than 30 nights. Is the ad still up today for less than 30 nights? Do you know?
I would have to verify that for you.
Okay. Thank you.
Yeah, that'd be great. Are you guys okay with hearing from the appellant while Mac looks that up? Okay, good, great. Hi there, you must be Destiny. I'm gonna have you open the mic. You heard my instructions. There you go, thank you. Give us your name and your address for the record, not the address of the property, because I understand you're a representative. And is there opposition to this case? There is opposition to this case, so you're gonna have 10 minutes total. Don't feel like you have to use it all if you don't need it, but do save a little time to counter what you hear from the folks here, okay?
Yes, ma'am.
Great.
My name is Destiny Klein. I'm representing Joseph Moy. The Airbnb is 1000 Warren Street. I reside at 3473 Golf Club Lane. I took over this property last year in the beginning of July. And so I've been working with Mr. Moy for about 3 years now as his personal house manager. Apologies, I am nervous. I'm very new to this.
You're fine. You're doing great.
So I took over, or I have been working for him for 3 years, and he brought up to me that he has an Airbnb, and it's not been doing very good. And I was like, oh, well, I would love the opportunity to just learn what that is, to, you know, just put something new under my belt. I'm young. I don't know what I want to do the rest of my life, but I want to do everything while I can. So I took that over at the beginning of July of last year. And whenever it was turned over to me, the grand welcome, they weren't helpful at all. It was very door code, figure it out yourself. I think it's just because we're taking a property from them, we're taking money, so I understand. So then whenever I took that over, I then began the process. It did resemble a 2013 Cheesecake Factory in there. So I took down all the decorations, put up new stuff that I thought was cute, painted the walls white, made sure it was very clean. I also wanted to make sure that it was a relaxing environment. I didn't want Dolly Parton and disco balls everywhere. I didn't want to push and or encourage drinking or anything. That's something I want to steer away from. Also, being a woman, I wanted to make sure that I was completely in touch with it. We had all the security measures, as well as when I moved here in 2021, I lived in a cul-de-sac at Hammock Court. I walked around to all my neighbors. I gave them cookies, introduced myself, and also invited them to a housewarming party. It's just who I am. I'm from small town Missouri. So when I took over that property, I also did the same with a sweet young lady right beside me. She's, again, a young woman beside my Airbnb. And so I wanted to make sure that she had my cell phone number and she could text or call me and had full access to any kind of just protection for herself. I want to make sure that she felt safe having an Airbnb beside her. I mean, things could happen. And so I wanted to make sure that everyone felt good. So then I redecorated the Airbnb, and whenever I told my friends about it, I was super proud. It's something that was so above what I felt I could do just with zero experience. So I was extremely proud. I was telling my friend about it, and she's like, oh, well, I have a friend actually who got given an Airbnb. She listed it, which I would also like to say I fell victim to the miscommunication on the Airbnb stuff. Truly, all you do is just throw a few photos up. I told them I love skincare and put a cute photo of myself up there, and it listed immediately, to the point that I even was like, whoa, I don't even know if I'm ready for this. And then tax stuff, all that comes later, which was completely confusing. So I tell them that it's listed, and then my friend said the friend who got given an Airbnb, she actually has ran it for years, and she's now getting sued because she didn't have the STRP permit. I was like, oh my goodness, I need to reach out about that. So I just Google it because I know nothing. And it said that the renewal is going to go to the email on file. Well, it's obviously not mine. I've had zero contact with this. Grand Welcome doesn't want to contact me at all. The last thing they said was that the STR permit renewal was July 2026. And I was like, okay, cool. I have so much time, or 2025, excuse me. I was like, cool, I have so much time. So then around March, I reached out, maybe May, I reached out myself to the board to just check on if it's active or not, just to make sure, because it said that that renewal is going to be sent to the email. So whenever I reached out, I gave them what you saw, all the information, and I was like, oh my goodness, it had already been expired, which was scary because my whole thing was I want to reach out months before so I don't have to do this and have shaky voices in front of everyone, which I love doing hard things. I'm growing, love that for me. I then ended up figuring out that I'm going to be exactly here today. But all this is good wisdom, good learning. Everything's going great in the Airbnb. I have beautiful guests. I've been listed for 3-4 months now, and I have amazing reviews. I've got people to the point to where they needed a toaster, and I DoorDashed a toaster within 30 minutes. And I feel passionate about making people feel loved, which is why it was such, I love this. I love the opportunity. I love the opportunity to keep this going. It is still listed. I would like to confirm that. That was the misunderstanding that I fell for. I blocked my calendar so nobody can, if you go on there, you can't book it because it's blocked. So that's a miscommunication. I did that wrong. I noticed that as soon as the first person came, so I tucked my tail underneath them. But that I'm going to save, I guess, because I have time. But I'm new to this, and I'm trying to get it all figured out. I want it to be, I see that there's past people complaining. I want to change that. I want this to be a spot where people can come, have fun, build memories, and then leave with cute little tulip trees and say that they had a great time.
Thank you.
Thank you. Does anyone have any questions?
Go. Did you have a question? Me? Yeah. Oh. I thought you'd raise your hand. I'm sorry.
I do think Mac has something to add. No? Okay.
Go ahead.
Okay.
Just wanted to verify the advertisement stuff should be on your screen.
Okay. Okay. Terrence, please.
Did you say there were 3 or 4 stays this month? Did I hear you correctly?
No, sir. As soon as I emailed to let them know, hey, I would like to just make sure this is active, and then, I asked to change the email to mine. So whenever it is time to renew, I could get it taken care of. And I wanted to be prompt on it. What was your question?
That was it.
So sorry, yes.
Yeah.
No, there was not. Sorry. Immediately after that, I tried to cancel it through Airbnb. I called the 1-800 number. They said that they couldn't immediately stop reservations until they got proof that this was a real legal action thing. So then it did go on, I believe, for like a week or something, because I had to get, which the board ended up saying that they can't do that. And so I had to end up just sending screenshots of the email and screenshots of the expired permit to Airbnb. And then they just canceled the remaining and then blocked off the calendar.
And when you say board, you're talking about the codes department?
Yes, ma'am.
Okay, yeah.
Whoever I'm emailing, so sorry.
Okay. Any other questions?
I guess a follow-up to that. So the last stays were in May.
Yes, ma'am.
Okay. Thank you.
Okay. So let me just clarify a few things. So, and I know you're new to this and you were not involved in the past when there have been issues with violations and, yeah. How involved is the owner? I mean, did the owner share with you that there have already been issues that had to be managed through an appeal process?
He had not. That's something, it's a pretty turnkey for him. It's something to where when he first moved to Nashville years and years and years ago, that's something that he lived there when we first moved here. And then it's been pretty turnkey. He's pretty hands-off. So I'm his house manager. And he's one of those people that just has a whole bunch of people that do stuff for him. And so, and good for him. So, he's hands-off.
Okay.
And I don't think there were I don't think there were appeals prior. I think there was just a back and forth, like the permit didn't get renewed the first year and then, but they hadn't operated. So under that ordinance, they could.
Okay,
Yeah.
because they were not subject to the 1-year waiting period.
Right.
Okay. All right. Yeah, but it hasn't been smooth, nonetheless.
And I'm assuming he didn't hand you at the time that he hired you on. I'm assuming that, because he was receiving these email inquiries as well, and as well as Grand Welcome, advising him that, hey, your permit's about to expire. Hey, the grace period is now run. What are your intentions? He didn't hand you any material saying, this is what I've received today.
No, sir.
Follow
So
up with Grand Welcome.
he has an assistant that handles his emails, which is frustrating because I wish they would have reached out to me, which is why I reached out to change the email to make sure I could be on top of it and be prompt with it.
Okay.
I do recognize that there's nuisances before me. I would like to make it clear that I want to make sure that it doesn't happen after me.
Okay. Any other questions? Okay, we do have opposition to this case. How much time does Ms. Klein have left? 4 minutes and 25 seconds. After we hear from the neighbors to the property, you'll have time to come back up and rebut anything you hear. 4 minutes and 25 seconds left. Again, don't feel like you have to use it all if you don't need it. If you want to just return to your seat and let these gentlemen come on up. Getting 2 for the price of 1, you gentlemen, today.
That's going to be more than
3
that.
for the price of 1, maybe?
Maybe 4.
Wow.
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 Proceed.
Proceed. And again, you have 10 minutes. Don't feel like you have to use it.
Should be short and sweet.
Okay.
I'm Dr. Kevin Griffith, president of the Hope Gardens Neighborhood Association. I live at 1013 Warren Street. For this property, this is a little different than some of the others because it was a failure to complete the paperwork, but we did discuss this at our last neighborhood association meeting, and there was some vigorous discussion over whether we should advocate for partial relief versus the full penalty, but there was definitely unanimous agreement that there should be a penalty, and the great preponderance, perhaps 21 out of the 25 people present, were in favor of upholding the full extent of the penalty.
The full 1 year. Up to 1 year is, I think, what we're governed with. Is that right?
But it was not unanimous. I think it was 6 months, according to the notice I received.
I think they thought it was 6 months,
Yeah, but
but
it's up to 1 year.
based on the ordinance, it's complicated. So, sorry, what you're saying is the vast majority of folks were like full 6 months.
Yes,
Okay.
the vast majority of folks believe that, this should be, issue as an issue of personal responsibility. They should, have the full penalty. There was a couple Airbnb owners in the audience, and they sort of suggested that because this could be a major tax to someone's likelihood or livelihood, a major revenue loss, that perhaps it should be a partial relief. But they were in a distinct minority.
Okay. Mr. Lynch?
Ed Lynch, 1018 11th Avenue North. So I was in attendance at that meeting, and it's correct, it was kind of like 21 to 4. Just a couple of things to note for this particular property, and I guess it would be for you to verify, but the owner is 100% out of state. They don't even live in Tennessee, so if they were to reapply, I don't know if they'd even be eligible as a non-owner occupied applicant. It's kind of a catch-22, if you will. But just to speak to the narrative from the lady before us on, making the Cheesecake Factory look nice, it was a lot more expensive than that. This is a professional investor. There was a crew of a couple of guys there for over 2 months, tarping the windows, working on this property to modernize it, to make it look like what you see in the pictures. So it wasn't teddy bears and candy trays to make it look nice and give it a little tchotchke. It was an overhaul. It's a professional investor. My question would be, if you write a check for however that much that renovation costs, how on earth could you let your permit, which is gold because it's non-owner occupied, expire? So there's something a bit weird here. Maybe they're looking to sell it or have deferred with the market back to Airbnb. I don't know, or maybe it was approached by the lady before me to manage it, but that's all I know about it, but it is vacant all the time.
Very good. Any questions for these gentlemen? Thank you so much for your time.
Thank you.
Ms. Klein, you're welcome to come back up if you have anything that you want to share.
Okay, yes, so he does live here. He's lived here for years now. He actually lives just 12 minutes away. I left his house. He lives in Forest Hills. And then I'm very proud of the work we've done. We did tarp up the windows and we completely changed it. If you look on the Zillow app, I think you'll be very proud. But I think that's just confirming he does live here, confirming that I apologize to the neighborhood for anything that's happened before me, and I take full responsibility for anything that happens after me. After me as being the reviews you see today. I've been on Airbnb for 3 months. I'm guest favorite. I'm top 1% of homes. I take pride in this. I take pride in the renovation. I take pride in this. I want to do it right. I want to make my neighbors proud. Just like I had made Darby proud, which is my next door neighbor, that I made sure that she was safe being a woman, and I want to continue to do this right.
Great. Any questions? Nope. Okay, we're going to close the public hearing. Thank you so much for your time. And we're going to discuss this amongst ourselves. Unless we reopen, we won't have comments. Okay. So, who would like to start?
I'll start. I'm really struggling with this one because I so appreciate Ms. Klein and the work that she has clearly done and her intention to be in good standing. However, she is the representative and not the owner, and I'm a little concerned about the owner's intention to stay in good standing when it doesn't seem like there was much attention paid to sort of the transfer over to Ms. Klein. That's my issue, that I'm trying to jump over that hurdle.
We agree.
I think that's very fair.
I think to me, in my opinion, the owner couldn't be bothered, and, in questioning Ms. Klein and sort of finding out about, sort of the way that information travels through her. It's not even directly from him. It's through an assistant that works on his behalf, and then you're having to put things together, and he's not giving you any information. There's just sort of no, it's sort of almost, I don't really care whether the permit exists. You figure it out, you worry about it when it's his permit. So there's just a very poor stewardship, in my opinion.
And I agree with that stuff. I mean, I'm also, I know we've kind of had a different basis today for like if ads are still listed, but, and I don't know if this is specifically on this point, but I would like us to kind of steer over time back in the direction of, really considering that as a mitigating factor, like whether the thing is still being advertised. I mean, that's something that people need to be able to figure out when they're out of compliance and are seeking to get into compliance.
It's pretty clearly, the stop work order or the violation notice is quite clear with that. So,
And I think that's why when we look at these cases, we've been saying, okay, you're still in violation today.
Right.
So that's the date that we've been choosing. But going back to just the idea that Ms. Klein is the representative and not the owner, and it is the owner's responsibility to ensure whoever their representative is, you don't hand off liability for complying with the ordinance because you put someone else's name on the permit.
Right.
And he's not here today to tell us anything, which is hard. It's hard for me to make a determination about whether to grant any relief because I don't know about his intent. I know about Ms. Klein's intent. I don't know about his, desire to maintain compliance, although it just, from the facts in the record and presented to us, it does not appear that he is very concerned with maintaining compliance. But it sucks, just like speaking frankly, it sucks because I think that Ms. Klein is doing the best that she can.
Yep.
But it's not, it's on him.
anything to add? We can hear you from down there if you did have something to add. I have to agree, I do think, hearing from Ms. Klein, I think we probably all feel better, and I'm sure the homeowners association probably feels a little better about the hands that this property would be in going forward, if that's any consolation. But yeah, it is, the stewardship has not been impressive thus far. It might be, starting when it can start up again. Sorry, go ahead, John.
Could we clarify for staff, could staff please clarify, if this board took no action on this appeal, when would the owner or the operator be eligible to apply for a renewed permit?
I apologize, could you repeat that?
If this board takes no action today, like grants no additional relief, when would the applicant be able to reapply?
Well, under the ordinance that governs this, you're required to make a decision.
I think, are you saying when would the 1 year start? Is that what you're asking?
Well, I didn't realize that was an aspect of, I don't even know which ordinance we're on here, but, so we do have to make a determination as to whether it's 3, 6, 9, or 12.
This is under 608, so yes, it reads up to 1 year wait based on the determination of the board. So
Thank
a
you.
determination does have to be reached by the board.
Thank you for that clarification.
Okay. What are you all comfortable with?
I'm not comfortable.
Well, what will make everyone a little bit unhappy, which I was always told is the sign of a good negotiation. I think there needs to be some waiting period to indicate that this is a problem.
Yeah.
Certainly.
There needs to be a waiting period that doesn't start.
I mean, it would need to
with
start
this-
today by,
I mean, the ad is still up. There
Yeah.
were guests as recently as when?
last month.
Yeah.
Yeah.
And yeah, so there has to be some waiting period. I don't know if it needs to be a year. I mean, I have a feeling if we were dealing with the owner, we might be less sympathetic. But I think if we choose a date that would give Ms. Klein an opportunity to set things right and get this property on the right track.
6 months came to mind for me.
Yeah, that
6 months,
seems
yeah.
from today.
Yes.
That feels reasonable, given that that's the default now. Although
Right.
we're dealing with the prior ordinance, but the board has discretion to set between 0 to 12 months. I think 6 months sends a message about the importance of compliance, but it also reflects the fact that the current representative is clearly very committed to being in compliance, which is the point.
I can see Mike shaking his head down there.
Yeah, I think 6 months is reasonable as well.
Well, then, in recognition of that, I will make a motion that we find that the zoning administrator did not err, and that we will impose a 6-month waiting period before the owner is allowed to apply for a new permit.
Beginning
Beginning
today.
Yes.
I'll
Second? Seconded? Can I see a show of hands? Unanimous amongst all voting members, Ms. Alicia. Okay, thank you very much, Ms. Klein. We appreciate your
Thank
time. You
you.
can communicate with staff about next steps. Okay,
Right.
we are on to our final case of the day, are we not?
Yes.
We'd never get here.
We've been pretty.
This is case 2025-015, 1024 11th Avenue North, Jarrett Lane, permit application denied. The property is not the principal or primary residence of the owner or appellant. This is an RS 3.75 zone district, which allows only owner-occupied permits. This is governed by BL 2020-187. The board has discretion under 2023-136. On January 1st of 2022, the appellant Jarrett Lane acquired the property at 1024 11th Avenue North. On March the 30th, 2022, an owner-occupied STRP permit application was submitted and processed, and the permit was issued. March 19th of 2024, a request for service, RFS, came through the office of the Hub Nashville, which read as follows. A short-term rental complaint description. This home is not occupied by anyone when it is not rented to the Airbnb. The owner is 100% absent and violating the STR rules. The neighborhood association wants their permit revoked or at least investigated for compliance. Inspector John Feltz opened a case file and began to investigate. On May the 2nd of 2024, a second RFS, or request for service, came to the office through the Hub Nashville, which read, short-term rental complaint description. This permit was issued based on a fraudulent application. They have an owner-occupied permit and states the number, and the owners do not live at the property. It is a full-time Airbnb/VRBO that can be booked anytime. The deed of trust for 1024 11th Avenue North contains a 1 to 4 family rider marked on page 2. The property address is on page 3. Number 6 of the Uniform Covenants occupancy requirement is on page 5. This requires the borrower to occupy, which is the appellant, to occupy the property within 60 days of the execution of the deed of trust and to continue to occupy the property as the borrower's principal residence for at least 1 year after the date of occupancy. The 1 to 4 family rider is the last 6 pages of the document. Section F waives number 6 of the Uniform Covenants occupancy requirement, and Section H contains the assignment of rents. Inspector Feltz found Mr. Lane owns several properties in Metro Nashville, Davidson County, as evidenced by the property assessor's website and NES records, one of which is 307 Bramblewood Drive. The Metropolitan trustee for the 2024 tax year has Mr. Lane listed as the owner with the address at 307 Bramblewood Drive. At the time of the revocation, Mr. Lane's driver's license was registered at 307 Bramblewood Drive, Nashville, Tennessee, 37211, dating back to 2010. Mr. Lane's vehicle registration was at 307 Bramblewood Drive. His voter registration was at 307 Bramblewood Drive. Current as of October 30th, 2024, Mr. Lane owns Tier 1 Consulting, LLC, which the Tennessee Secretary of State lists as the mailing address as Jarrett Lane, 307 Bramblewood Drive. Also, excuse me, also Tier 1 Concepts, the Secretary of State lists the mailing address as Jarrett Lane at 307 Bramblewood Drive. Excuse me, registered agent is Jarrett Lane with the addresses 307 Bramblewood Drive, and the principal address is 307 Bramblewood Drive. The 2024 homeowners insurance policy for the owner-occupied STRP at 1024 11th Avenue North has the owner Jarrett Lane with the mailing address as 307 Bramblewood Drive. In October of 2018, the appellant Jarrett Lane was a plaintiff in a civil suit in which he registered his address as 307 Bramblewood Drive. Again, in a civil suit filed on September the 9th of 2019, in which Mr. Lane was the plaintiff, he listed his address as 307 Bramblewood Drive. The deed for 307 Bramblewood Drive names the grantees as Jarrett Lane and Jennifer D. Nishke, FKA, formerly known as Jennifer D. Lane, whom we believe is to be brother and sister. You can see Mr. Lane's Facebook page. Based upon the information listed above and using the Tennessee Code annotated 2-2-122 Principles for Determination of Residence Factors involved, the following factors among other relevant matters may be considered in determination where a person is a resident. The person's possession, acquisition, or surrender of inhabitable property, the location of a person's occupation, the place of licensing or registration of the person's personal property, the place of payment of taxes which are governed by residents, the purpose of a person's presence in a particular place, and a place for a person's licensing for activities such as driving. The determination was made that the permit would be revoked due to a lack of primary residency. On November 23rd, 2024, the revocation letter was sent out, and the letter stated that the revocation would have an effective date of December the 8th of 2024. December the 11th of 2024, Inspector Phelps found that the website advertisement remained active. He made a visit to the property and posted a copy of the revocation letter and the stop work order, which is documented with photographs. On December 30th, 2024, I received a public information request from the Assistant Director of Public Affairs and Development, Mr. Will Dodd, requesting all information related to the STRP permit for Jarrett Lane, investigation of the permit holder's compliance with rules and regulations. The public information request listed the contact's name as Jarrett Lane at address 307 Bramblewood Drive, Nashville, Tennessee. I scanned and emailed the requested information that same day. We anticipate that the address on some of the documents may have been changed after the public information request was received. There were 2 complaints on the Hub Nashville that were described earlier in the presentation, both of which claimed that the owner does not live at the property. There were no complaints on the STRP hotline. There are 3 letters in opposition to the appeal being granted, and Metro's compliance contractor, Granicus Host Compliance tracking of the website advertisement for this property has 2 documented stays in January of 2025 after the revocation date of December the 8th, 2024.
Okay,
And I believe there is opposition in this case as well.
Mr. Lane? Great. What? I'm sorry? Okay, we haven't started yet, so can you just take a breath for 1 second? Are we including your mother in the comments, or are you just using her as evidence?
Well, I was going to ask that question.
Okay.
How would you like me to
All right,
approach this?
I have a question for staff too.
go.
just
Let's handle our housekeeping issues first.
Okay, so, I'm looking at all of these documents, and it doesn't look like any document has the 11th Avenue North address listed on there. So, is it possible for you to tell us what documents codes reviewed in 2019? I know that was 5 years ago, but to determine that this was the appellant's primary residence?
I most likely can find that for you.
Okay, and that's fine, I'm fine to move on
Okay.
while you look.
2022 though, right? Didn't it just get issued for
Oh.
the first time in 2022?
Sorry,
Yep, it was the last
2022.
case that was 2019.
Yes, 2022.
Yeah. Okay, and, okay. I think, Anne, if, what I'm gathering is that part of what Mr. Lane is going to claim is that the home in Brentwood that seems to have that is listed quite a bit associated with his documentation, he's got his mother here. Do we need to hear from her?
If she's going to testify and offer evidence, then yes, she should come up and testify and give her name and address.
Okay, all right, that is what we will do. Okay, ma'am, could you come forward too? And you can have a seat with your son. Thank you so much for your patience while we figured everything out. So we are going to hear from you folks first. You'll have 10 minutes between the two of you. Do save some time to rebut anything that you may hear from those here in opposition. And don't feel like you need to use all of it, but we will keep track of the time and we'll tell you how much time you have left to use after we hear from the opposition in this case. So are we good to go? We can wait on that. So, Mr. Lane, we're going to get started with you. If you can start by giving us your name and your address for the record, and then tell us about your situation.
You said just hit this once?
Just once.
3 dots, correct?
Yes, but 3 dots one time.
There we go.
Is the red light on?
It's the one with the person talking. It's not the 3 dots.
Sorry,
There you go.
Good to go?
I misinformed you. And that'll go for you too, ma'am, that you're going to hit the one that looks like a little person. Okay.
Okay, so my name is Jarrett Lane. I do live at 1024 11th Avenue North, and I'm happy to go through all of this. Unfortunately, I just flew in from New York, where I'm managing part of the new JFK Terminal 1 there. So I'm in and out of town at least 2 to 5 days a week, alone with that project. So I'd like to start with chronologically. I didn't understand why anything before 2022 was relevant or included in the investigation, because I don't know how that's applicable to the property I purchased in 2022 and the application for my STR after that. The civil cases, all of my driver's licenses that were shown in his investigation, I know they're trying to do their best, but they all show expired 2018 or earlier. And for some reason, like with the licenses, for example, my license has and still does show 1024 11th Avenue and has ever since I purchased the property. And I didn't know if I was missing something along the way with why those were included when they were before I even purchased the property. That being said, so I want to kind of go over the timeline and how it played out for things on my end. So the first time I realized there was a stop work order was when the notice was posted on the door. I immediately reached out, started emailing codes, trying to figure out what was happening with the 14-day notice that I was supposed to receive, so I had some sort of heads up. Back and forth emails, we identified the tracking number where the mailing for the notice shows that it was not delivered. And in talking with their office, I guess the position of the office is that once they send it out, that's all they need to do to comply. But it makes it challenging for anyone just trying to get ahead and be in compliance if they have no way of being noticed. And I don't know if they would have included that in the legislation without that being the intent to begin with. So went through emails, set up a meeting to sit down with Mr. Hargis, who I've worked with before on some other properties, because I do own several long-term rentals. And I was previously in a partnership for some other long-term rentals in the area, which as of March, I was already resigning from. And, this is all paperwork that I brought. Unfortunately, I do not have that to provide with you because I wasn't able to get copies in time. I'm happy to provide that as a subsequent after this meeting if you would like. But I had no way of being in compliance with that with my flight being delayed this morning. So sat down and both of us spoke with Mr. Hargis and explained to him that after my father died in 2017, in order to take care of my mom, she's retired, I took over paying the mortgages direct. The property was in my sister's name at the time. And I maintain to this day that as a mailing address for almost everything because having anything sent legal notice wise or since it would work, I have to maintain that per the state law at a place where it can be received. An Airbnb would not be in compliance with that. I wouldn't have anyone there during normal business hours per state law, so I had to keep it with her, or it was prior to that when I initially started my LLC. It was over in Chestnut Mountain, Tennessee, in my uncle's farm, but in the past 2 years, I moved that over here to Nashville so that I knew somebody would be there to be in compliance with that requirement. Obviously, I've been in some civil suits. These were all where I was plaintiff. I was not defendant, and justifiably so. And they've both gone my way for obvious reasons. And so I'm mindful of being, in a good position to, be in compliance with things and not have exposure. Kind of moving forward, I was also confused with deed of trust references that were made. The 1 to 4 family rider was exclusively removed, but it was mentioned as a factor in his investigation. So I don't understand why those two. What the important point was that I would have liked to kind of sit down and kind of go over this to better understand some of this stuff, but it's a lot of questions because I got this dumped yesterday morning, yesterday afternoon, so I'm still, I was just going through it just this morning trying to wrap things up. And the assignments of rents is only in reference to if the property is in foreclosure or defaults in the loan. So I didn't understand what that was in reference to either on the deeds with my 1024 property. The other properties that I own around town, that evidence I actually provided initially when I came in to speak with Mr. Hargis. I remember kind of being concerned to leave some of the documentation there. I felt like, after watching for the short-term appeal board YouTube videos for 2.5 years to make sure I wasn't going to be out of compliance, I felt very nervous about, things being used against me, when they may be represented in a way that's not accurate. So I was told that documentation that I left with them would not be, used against me. And unfortunately, I, see, for example, the Allstate insurance page where I list my other properties that are on there, included in this package. And I don't understand what those are involved with, because the insurance list all of those properties as a landlord package, and they are. The only property that has a homeowner's policy on it is 1024, and my vehicle registration is actually registered at 1024 and has been for over 2 years now. I have a copy of that. I think what they saw was the vehicle plate that I had mailed to 307 Bramboy Drive, because when it was issued, it had to be mailed to me. Again, I don't want to have things of a sensitive nature, of any personal information, if I can avoid it, sent to an Airbnb, especially in this area. I mean, I know most people are aware of some of the challenges in this area. I've run off several homeless people, and I've had multiple break-ins. I've had people steal furniture out of my backyard twice, so it's not exactly what I would consider a secure location 100%. So having that, sent to my mother over in Creve Hall is a much better option. And I think most anybody would probably make that decision, put in my shoes. I also have, all of the utility bills for water NES for the last 2 years, showing Marlene Lane is the owner. I have the homeowner's insurance policy for 307 Bramwell Drive, showing Marlene Lane is the owner. This is the vehicle registration showing 1024 11th Avenue from 2025 and 2024 into 2023. So 9/1/2023 through 7/31/2024, and then moving forward in 2/6/2025, and then it doesn't expire until 2/28/26. And there was a gap in there just because I simply didn't drive it. I don't even store that vehicle at that property because it is a high-risk vehicle. It has a Hellcat engine in it, if anyone understands what that is.
So that's your full 10 minutes.
Okay.
Does anyone have any questions for Mr. Lane?
I do.
Please, go right ahead.
So I want to make it clear to you, I had similar questions about why things prior to 2022 were included. I think routinely we understand like the timeline. Even though I said 2019, I promise you I do understand the timeline here. Where did you live prior to 11th Avenue North, and when did you move in to 1024 11th Avenue North?
So I've lived in the
Like just immediately prior?
locations of residence was either 6523 Cougar Drive or 902 Patricia Drive, both of which are long-term rentals of mine. And what I've done over the years in order to build a retirement plan for myself in a future where I potentially, if I get hurt or something, have some sort of financial security, is to move into a property after I would purchase it. I would renovate it, and then if I was able to get a tenant relatively quickly, I could then choose to move out if the price was right, and I could keep on traveling with work, because it wasn't necessarily something I needed. I guess with the contracts that I had, it wasn't. It didn't really matter to me. The purpose of those properties was to create financial security for myself in the future.
Okay, and when did you move into the home at 1024 11th Avenue North?
So that was in 2022 when I purchased the property. I haven't had another residence since that point. I haven't had a driver's license. The only thing that is going to be visible on any of this is a mailing address. And again, that's for security purposes. I'm not storing my vehicle down here. It's going to be stolen in 3 days.
Okay. I'm not coming at you.
No,
I'm
I
just
know.
asking. I know it's
I'm
stressful.
sorry. I didn't mean to.
That's okay.
Yeah, it's just really stressful. And
I understand.
Yeah. I've watched these videos for 2 years, and I understand what you guys are tasked with, and I understand what the codes department deals with. I've been dealing with codes for a long time on other things, and I've tried to be 100% transparent about the board. Obviously, I have a whole stack of papers here looking like a crazy person, but there is a reason for this, and it's to obviously protect myself and justify you know, what I know to be true and evidence that for everyone else. So it's not just like what seems to be on some of these claims that maybe initiated this case, which is just hearsay and claims, where I'm trying to bring receipts.
Got it.
Speaking of receipts, you said that you have your car registration that shows the address as
Correct.
11th Avenue.
Yes,
Would you
ma'am.
be so kind as to pass that to Mr. McBroom and it'll be
Absolutely.
shared down the road? But can I just confirm that your voter registration as of October 30th of 2024 shows 307 Bramblewood Drive?
Yes. So I can speak to that, and then
Your,
she
your,
might.
your
she-
mother's not recognized and didn't, yeah, so we're not gonna do that.
Okay. Don't.
Well, I think
We
if
could
he wants
reopen
her,
the-
the public hearing is open though, right? So
Right,
if he wants
but her
to,
10 minutes is gone, his 10 minutes is gone.
right, but questions don't count against the 10 minutes. Am I crazy?
I think
But she wasn't introduced during that 10-minute period.
I think a question could be directed to her if someone has a question directly for her.
I was just asking, couldn't he have whoever he wants to answer the question? If they introduce themselves?
Well, I think the question is, it depends who the question is directed towards. If it's a question for him, then he
think-
needs to answer it.
Right, yes. Right.
Yeah. And just a note, so are you submitting these documents like into evidence here? Because I guess you don't have 8 copies for everyone, correct?
Unfortunately not.
Okay, because that's in the rules too, which if you
Yeah,
watch.
I'm
many
going
times-
to look at it, and we're all going to look at it, but it doesn't hold the same weight as bringing 8 copies, which is what's
I
required.
understand.
But anything that this body's going to consider, we need to make sure there's a copy of that on the record.
Okay.
I'm sorry, Madam Chair, I didn't mean to interrupt. You
You're
were,
fine.
I think, asking a question.
Yeah, so did you vote in the last election?
I did.
And you voted with 307 Bramblewood Drive
I did.
as your address?
Yes, ma'am.
Okay.
Could you provide an explanation?
Absolutely. So, I take my mother to the voting booth when she wants to go voting early. We go approximately 2 weeks early. We go to the Edmondson Pike Library. That's where we've been going for 10 years. And she had mentioned that a while back that, oh, well, early voting, you can go anywhere you want. And I said, okay, well, when I come in town, I'll take you to go vote. And that's what I did. And I was not under the impression that if I was doing early voting and I could vote anywhere, it mattered what the address was necessarily.
How did you answer the question when they asked you if your address had changed since the last election? Because your address was 307 Bramblewood, and you were living, according to you.
But I only have a driver's license that shows 1024.
No,
Right,
when
but-
you go to vote,
Yes, ma'am.
as Mr. Bond just said, you hand your driver's license,
Mm-hmm.
and the question is, has your address changed since the last
Oh,
time you voted?
no,
So you answered no, it hadn't changed.
no, ma'am.
Right.
And you made that response under penalty of perjury that your address had not changed from 307 Bramblewood, which is what your registration shows.
So I understand, and this is what I talked with Joey.
Because
when
you
I-
have to sign the form.
When I
before you-
came in,
right.
obviously I had that 1024 driver's license. I don't have a 307 Bramblewood driver's license.
Okay.
And I had this conversation with Joey when I came in to speak with him about it, that both of us did, we did not know that. It was a miss on our part. And, that is something I can take ownership of. I'm not sure if it's, it was a miss, and that is something I've corrected moving forward. I have the documentation. I've gone and changed my voter registration card at this point. Obviously, I've done it for a reason. I've done it that way for a long time. No malicious intent. But again, that has been corrected moving forward, and it was identified and discussed transparently back in January with Mr. Hargis.
Okay, thank you.
I think you also mentioned in passing, or as you were talking about like utility bills and the like, did you say that your mom owns the Bramblewood Drive home?
No, she does not own it.
Okay, I just want to make sure that we're all in agreement on that. Anyone else have any questions? Mike? Go ahead.
Another question. You'd mentioned in your presentation that the Family 1-4 rider had been at some point jettisoned from the agreement. Do you have the date on which that happened?
It's
or-
actually, yes, sir, I do. So actually in the back of this, and I think he was able to reference it in his,
Oh, do we have that?
yeah, because it looks like, I can't even remember how this played out, to be honest with you. It's been a while, but that rider was in earlier, farther up in the deed, and then there's an addendum at the back that removes it.
Can anybody?
Where was the
give me
exact
some
language?
direction on what page
So-
I'd
Here,
find that
I'll give
on?
you the whole thing.
Okay, thank you. Because I have the deed.
Yes, unless the lender and a borrower otherwise agree in writing, section 6 concerning borrower's occupancy of the property is deleted. And this was part of the recorded deed of trust document, the same document that actually introduced this language that he was referencing. So this came from the lender, and this was like a very unusual lender from some of my other properties that I've worked with, so.
Yeah, I see the 1-4 rider. I just need to see the section they're reading it.
And Mr. McBroom, did you happen to come across what materials were used in the original application?
It was a checking bank statement, checking account bank statement, and homeowner's insurance. But I have just checked the records with Davidson County, and that 1-4 family rider remains on that deed of trust.
I'm not seeing anything that actually amends the deed to remove it from the language.
Okay.
I mean, listen, my eyesight is not the best, so I'm not saying.
Mr. Lane, thank you very much for your time. We
Sorry, I
appreciate.
had one more question.
Okay.
I'm sorry. Who lives at 905 11th Avenue North?
Caitlin Frisch.
And what is her relation to?
So Caitlin Frisch, as of March of this year, is my fiance, and
Okay.
they were able to find the wedding registry online that we recently put up. And that is also why back in April, we decided to go ahead and market that property. That property is currently listed for sale. It's not something we're going to be moving forward with renewing. And it was because of my conversation with Joey, which I think he spoke to earlier about how married couples are going to be viewed and should be viewed as it regards to the short-term rentals.
Got it. But y'all aren't married.
Not yet, no.
Okay. Well, congratulations on your engagement.
Thanks.
Okay. If there are no more questions, we're going to hear from your neighbors. So you can return to your seats if you like. And as you heard, your entire 10 minutes have been used, so there won't be any opportunity to rebut.
Understood.
And ma'am, are you here in opposition to this case as well? No? Okay. We have really good air conditioning in here. This is the place to be today.
We do now, yes. Took it a minute.
Look who's here. It's Dr. Griffin and Mr. Lynch. Griffith? Did I say
Yes.
Griffith? I apologize.
Don't sweat it. Proceed.
I was trying to turn you into Family Guy characters.
Oh, my gosh.
Sorry about that.
Oh,
Okay.
Hopefully not in a physical resemblance.
So for the record, your name and your address. And
I'm
tell us
Dr.
about
Kevin
the
Griffith.
situation.
Dr. Kevin Griffith, resident 1013 Warren Street in Hope Gardens. I'm the president of Hope Gardens Neighborhood Association. I'm very familiar with this property. This is a full-time Airbnb. Mr. Lane is a stranger to me. Despite having line of sight from my property, I've actually never seen him at the property. It has also been notified to me by several residents, both on Warren Street, which is adjacent across the alley, and on 11th Avenue North, that this is a full-time Airbnb. None of us have seen him in the neighborhood. To give a couple anecdotes, not to complain about property standards, but to simply to illuminate the lack of him being present, when the backyard furniture was stolen, as he referenced, the chair pads were left, and they were left there for several weeks before I eventually reached out to him. I found him on Facebook and had to contact him and let him know this had been stolen, because the people that come and clean the property after the Airbnb guests leave apparently did not notify him. Also, you know, when they don't have guests, the mail is overflowing because there's not someone there at all. So this was...
Sir, please.
This was discussed at our last neighborhood association meeting with 25 members present. It was a unanimous vote that the neighborhood association is in opposition to this appeal because he does not live at this property, nor at the other property that was referenced that's also in Hope Gardens.
Any questions for Mr. Griffith, for Dr. Griffith, before we hear from Mr. Lynch? Okay.
Okay, Ed Lynch, 1018 11th Avenue North. So, as my address would suggest, I live 2 doors from this property. I work from home from 7 a.m., usually 7 o'clock at night. I've got a clear line of sight on anybody who can comes and goes to that property or the one beside me, and there's a vacant lot in between that. A stranger to me, as Kevin has said. I remember the day the property was sold. A young man died and his mother moved and sold the house very quickly. It was given a quick lick of paint, about a week's worth of work, and then it immediately became an Airbnb. The Airbnb guests kept coming and going. On one occasion, there was a couple of kids from Indiana who were down, who were having a huge party in the back. It's got a wide open lot. It was loud. It was 11 o'clock. I politely approached them to quieten down. They invited me in for a beer. We're Airbnbers, all that goes with it. What I think's amusing is right now, there is a lady living in the house since the notice went up about the appeal, who introduced herself to me. Actually, her dog ran up to my door and I texted her, like, have you lost dog? She introduced herself as living in 1024, as a renter, and only as of Sunday came back to ask me, did I know the people to the right of her, because it's also an Airbnb and she's having an issue with them. So if Mr. Lane's living there permanently with his fiancée, I've never seen them, and there's somebody living in their house full time. She was watching TV last night. I walked by and saw her. So that's...
So just to confirm with both of you gentlemen, before we let you go, and if anyone has other questions, the issue at hand, of course, is whether or not Mr. Lane lives there full-time, and you gentlemen both represent that you're obviously very active in the neighborhood association, and this is not someone that you're familiar with. And since 2022, even someone who travels a lot, this is not someone that you would say lives in that house.
That's correct. I do speak on behalf of the neighborhood association as the president, but also I do have personal experience with this property, given the line of sight from my own. I have not seen this gentleman. He has never come to a neighborhood association meeting.
And not everybody's a meeting goer.
Right.
So
and the
to be
property,
fair,
when there's not an Airbnb, there are no cars, there's no person present.
As
Mr.
an
Lynch.
aside, when the Airbnbers leave, before the notice went up, and I think there's a temporary 30-day renter in right now, but prior to that, when the Airbnbers would leave, because my back alley is shared to get to my house, I passed that one. I basically have turned into the garbage guy, because the Airbnbs have, bountiful beer cans, all of it, pizza boxes, and routinely I would have to pick up that home's trash to put in to get to my own before it spread out all over the alley. Which would not be indicative of somebody who lives there, to have their trash settings sprawled out for 3-4 days all over the alley. So we both picked it up. We share the same alley to our homes.
Understood. Any questions? Gentlemen, thank you so much for your time. We are going to discuss this amongst ourselves. Am I good?
Say close public hearing?
Yeah, the public hearing is closed, so unless we reopen the public hearing to further our conversation with any of the parties here, we're just going to discuss this amongst ourselves. So thank you all so much. Anyone want to start?
I'll start. Why not? Surprise. Given the materials that codes had available to them at the time they made the determination, given the testimony from neighbors who live nearby. I am not inclined to grant relief here because I'm not convinced that this is the appellant's primary residence.
You know what I'm gonna say, if you make a statement under penalty of perjury that you have to sign, certifying that you live at a certain address for the purpose of exercising your voting rights, that's dispositive for me. So I'm not inclined to do so either.
Sean?
Yeah, I mean, looking at as Nicole said, the materials that the zoning administrator and staff reviewed, I think it was a reasonable determination. And then having heard from the neighbors that have daily observation and experience with this property, I'm just not convinced that the zoning administrator erred.
I'm in agreement, based on the evidence and the testimony from the neighbors and the association, that this is also not the appellant's primary residence.
Okay. Well, then I'll make a motion that the zoning administrator did not err in this case and that we won't be providing any relief. Do I hear a second?
Second.
May I see a show of hands? Okay, we have a unanimous vote from all voting members. So, Mr. Lane, thank you so much for your time today. We wish you all the best. And gentlemen, thank you so much for coming and speaking on behalf of the Hope Gardens Neighborhood Association. Thank you again for your time today, folks, and have a good one. The hearing is closed. The meeting is over. The hearing is closed.
Does this need to go
Oh,
over there? Or do
yeah.
I need-
So, Mr. Lane, sir?
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.
For today's hearing.